governance and ethics component to this. Let's turn to York University's Richard LeBlanc. Good to have you with us.
Hi, Michael. Nice to be here.
How likely is it they didn't know this merger was going to happen when they issued that statement?
Unlikely for a spike, for a stock to spike 12%. There will be private prosecutors and public regulators that will look at the trading patterns of brokers and of insiders and of tippees. What happens in situations like this is you have conversations in elevators, you have conversations in dining rooms, one thing leads to another, and a tipster tips to an outsider, and stock begins to trade. So there's going to be harsh public scrutiny on the role of the boards of directors of both companies, but particularly Lakeshore, in terms of its insider trading policy and its disclosure controls.
Is there any justification while you're working behind the scenes on a merger and you see your stock spike before the announcement to say, I don't know of any material reason for my stock going up?
The statement by the company on its face appeared to be accurate. The issue is, what are you prepared to do? If the company discloses, if a company discloses, we are not aware of any breach of insider information, a good board would exert control and would bring in a team of forensic experts, and they'd look at emails, they'd look at texts, they would direct reporting management to preserve evidence, not to tamper with any investigation, and likely that is what could happen to a company like this downstream, is they end up being sued by plaintiffs' attorneys. And what the plaintiffs' attorneys will allege is that 12% spike was owed to all shareholders and not potential shareholders that got inside information or got it in advance. So it's taken quite seriously, both by the public prosecutors and by private.
Whether it be insider trading or insider tipping investigations, we don't get a lot of them in this country, and we don't get a lot of prosecution on them. I can imagine, because it's very hard to prove that somebody overheard something in an elevator.
That's exactly it. There have been only a few cases. In one case, there was a law firm that one of the partners told his fraternity friend of something. It's difficult to prove, but good companies will educate employees under no circumstances are you to talk about any transaction that could be material, and they take it very seriously. So it's unfortunate that it occurred. It tends to occur infrequently, but when it happens, it's taken very seriously.
Is the punishment that's meted out sufficient to curtail future crime? Are we hitting Bay Street hard enough to ensure that that loose lips don't sink these types of ships?
There is a school of thought that because we don't have a national public prosecutor, public regulator, that the private bar is much more lethal on companies. By private bar, I mean plaintiffs' attorneys that will sue the company and will sue officers and directors, which will be enormously distracting. But ultimately, you want to find how this leak occurred.
When you say enormously distracting, to what degree? As an investor in any company that might find itself under this kind of investigation, and again, we don't know explicitly that that's the case in the OSC at this moment, but how significant of a distraction is it for a board to the point where it would move or not move the needle on an investment thesis?
It's distracting enough to conduct an independent investigation. I mean, generally, if you're on a board and the stock starts going up, you have to make a decision. Are we going to act independently and bring in an independent team? Are we going to? And what's the loss? What's the downside? If you bring in an independent team and you find that there was in fact no tipping, likely or unlikely, but at least be proactive about it and begin to conduct a proper investigation. So yeah, that is distracting and it's costly. But again, it ought not to have occurred to begin with.
I'm going to ask my ace producer and three-time NASCAR champ, Franklin Cameron, to pull up that quote again from Lakeshore Gold.
Right.
Because it strikes me as odd that you suggested that saying, quote, not aware of any material, undisclosed corporate developments that would account for recent trading. Like, that's factually accurate.
Correct.
Lakeshore would clearly know that they were working on a merger. Correct. Unless they worked it out over
disclosure is the operative word.
Is that?
Yeah, so they're not aware of material of deliberate or inadvertent disclosure to the market. The issue is, I may not be aware of something, but do I have an obligation to investigate? That's the issue, right?
So they wouldn't have an obligation to say, well, the stock spiked, so we don't know if it leaked out, but we're working on this thing.
That's where the board should come in. That's where the board should come in and direct management. Listen, either postpone the merger or conduct an investigation, but leaving it to a technically correct statement is really not helpful for the market.
Richard, we appreciate your time. Thank you
My
very much
pleasure,
for your
Michael.
insight. Richard LeBlanc is the Associate Professor of Governance and Ethics in Law